Pursuant to Rule 7B of the Rules of the Council, the committee intends to receive a presentation from Dr. David Keanu Sai relating to an update on land use and planning in consideration of Hawaii's status under international law and other related matters. The related matters would be the land titles and seized lands. So the reason that I scheduled this item is it's a continuation of the first question on the first workshop. I knew that we're probably gonna have to make decisions and hear about issues dealing with what I thought was ceded lands, and then after the first and second workshop, we learned it's actually unceded lands because there's no treaty of cession, so you can't have ceded lands. So you can call them seized lands or unceded lands, and then that information, I guess, led to the issue with most all titles because of the illegal annexation and occupation. So this is just a continuation on that theme, and us as decision makers, not being grown up, taught this kind of history of seized lands, annexation, and like that in regular public school or most private schools. Thinking that we need a workshop to make informed decisions from all the testifiers and the presenter, and even your own background work that you choose to do. So I have here today Dr. David Keanu Sai, and Dr. Sai has a PhD in political science, specializing in international law, state sovereignty, international laws of occupation, United States constitutional law, and Hawaiian constitutional law from the University of Hawaii at Manoa. Because of his expertise in these subject areas, the chair will ask he be designated as a resource person pursuant to Rule 18A of the Rules of the Council if there are no objections. So no objections. Dr. Sai, can you proceed with your presentation at this time?
Thank you, Madam Chair.
Thank you.
What's good back here again? Aloha. Well, it's good to be back here again. A lot of things happening on the Mauna. Wow, that thing is really galvanizing a lot of people. I think what it's also doing is getting people to start ask the right questions. That's what's starting to happen, and that's good. To me, I don't take it as what side you're on, just really the questions. And these questions are going to lead to answers. And no doubt, as we covered before in the last two presentations, that would open it up for more questions. And that means we're on the right path, right? We need to try to understand what's going on. Now, my background that I bring to the council here is my background as a political scientist. My law journal articles, my publications. In fact, I just got word this past month that Oxford Press asked if I could write one chapter on the Hawaiian Kingdom, which is a book of non-European powers in the age of empire. So word is even getting out beyond Hawaii, right, with regard to how we are tackling Hawaii's history, okay? Now, this presentation that I'm going to be giving is going to be focusing on land titles. And I'm going to touch upon the so-called ceded lands and why they're not ceded, and then also as it ventures into private lands. Private lands that are not ceded, but were held in a private capacity. Okay, so just to recap, as far as the why the Hawaiian Kingdom still exists, I'm talking about the Hawaiian Kingdom as a country. I'm not talking about the Hawaiian Kingdom as a sovereignty group. My great-grandfather was born in 1880 in a country called the Hawaiian Kingdom. So that's what I'm referring to, is the country, not the government, right? Well, that country received its recognition of independence in 1843, specifically November 28th. That day, November 28th, La Kuoko'a is Independence Day. That was a national holiday in the kingdom. So my great-grandfather in 1880 would probably be celebrating on November 28th 1893, the 50th anniversary of Hawaiian independence. In fact, it was going to be celebrated across all the islands. Now, that country called the Hawaiian Kingdom was represented by a government called the Hawaiian Kingdom government, and it was a constitutional monarchy. Okay. Now, in 1893, we know that that government was illegally overthrown by the United States military. But by overthrowing the government, that did not mean the country ceased to exist. And we covered that in the last two presentations, the workshops. So just as Saddam Hussein went into Kuwait in 1990 and overthrew the Kuwaiti government, that did not mean Kuwait ceased to exist. Kuwait was still a country. It was called occupation. Now, how I know that? Just from my military experience. In 1990, I was in Fort Sill, Oklahoma, as a captain, going through Officers Advanced Course. We knew the country still existed, despite the government being overthrown militarily. Despite the fact that Saddam Hussein in Baghdad unilaterally annexed Kuwait and called it an Iraqi province. We knew Kuwait still existed. Our job back then was to get the Iraqis out of Kuwait, not to restore the country. The country never left. But getting the Iraqis out, and then the Kuwaiti government comes back in. That's exactly what happened in 1893. What was overthrown in 1893 was the Hawaiian government, which the President of the United States, Cleveland, said was illegal. He said that the existence of the provisional government is tied directly to an armed invasion by the United States. Despite that, the country called the Hawaiian Kingdom still exists. It's just that there's no government there speaking on behalf of the country. Okay. So now that we know that the Hawaiian Kingdom continues to exist, but it has no government, how does the United States, or how did the United States acquire the country called the Hawaiian Kingdom? Well, according to Professor Oppenheim, leading expert in international law, he says cession of state territory is the transfer of sovereignty over state territory by the owner state to another state. So when you hear the word state, they're referring to country, right? Sometimes called nation state. And the only form in which a cession can be effected is an agreement embodied in a treaty. So you need a treaty where one country, through its government, is going to cede its territory to another government. So here we have two sovereign entities, two countries being represented by their government. One government will cede territory to another country, right? And it can happen either during peace, a voluntary transfer. See, this is where the word cede comes from, or ceded lands, from cession. Or actually an involuntary cession, called a treaty of peace, which ends a war. So here's the United States, just to recap what we covered the last workshop. The United States acquired its first cession from France in 1803, called the Louisiana Purchase. That is called ceded lands, right? And America actually bought those lands for $14.5 million at that time. The place we called Florida was transferred by the Spanish in 1819, ceded lands. So prior to 1819, Spanish law applied over that territory. After 1819, American law. The Pacific Northwest, transferred by the British in 1846. Now, way up north in Alaska, 1867, Russia ceded the Alaskan territory to the United States, which gave the Congress the ability to create a territorial government for Alaska in 1912. And then in 1959, Alaskans, who were Americans, voted through a plebiscite to change the name from a territory of Hawaii to the territory of Alaska to the state of Alaska. But you need the treaty first. Now, those were all transferred voluntarily. We have an example here, involuntary transfer. Well, actually, it was voluntary because they signed a treaty called a Treaty of Conquest, Treaty of Peace, and that's 1848 Treaty of Guadalupe Hidalgo. That ended the Mexican-American War, and all territory north of the Rio Grande then became U.S. territory. Prior to that, Mexican law applied. So what is the authority of the annexation of Hawaii, right? We can't jump straight to statehood, 1959, because there was a plebiscite. we need to find out whether or not there was a treaty. Well, in 1898, July 7th, instead of a treaty, what we have is a joint resolution to provide for annexing the Hawaiian Islands to the United States. It's not a treaty. It's an American law. American laws apply to U.S. territory. Treaties apply outside of your territory. If you notice also in that joint resolution, it says that the Republic of Hawaii cedes and transfers to the United States the absolute fee and ownership of all public, government, or crown lands. This is where we get the idea of ceded lands. The problem is, that's not a treaty. That's legislation. That's as if Maui County Council passed an ordinance annexing Hawaii County. You have to have an agreement between Hawaii County and Maui County. That agreement, in international terms, would be called a treaty. But Maui County can't create an ordinance annexing Hawaii Island. Now, what's interesting is, here's a little tidbit from Maui itself. The Maui News, October 20th, 1900. G.B. Robertson is the editor, and he's going to be he's writing an editorial with regard to Thomas Clark, who's a candidate for territorial senator from Maui, 1900. So he writes, Thomas Clark, a candidate for territorial senator from Maui, holds that it was an unconstitutional proceeding on the part of the United States to annex the islands without a treaty, and that as a matter of fact, the islands are not annexed and cannot be, and that if the Democrats come into power, they will show the thing up in its true light and demonstrate that the islands are de facto independent at the present time. Obviously, Thomas Clark knew there was no treaty, but he also knew Hawaii is still independent. It's not part of the United States. So the response by G.B. Robertson, the editor, says, Thomas, necessity knows no law, and it was absolutely necessary to annex the islands at the time it was done. And further, Thomas, if it becomes necessary to annex Cuba, it will be done quicker than a wink. It is but fair to give you credit for being honest in your views, Thomas, but you don't quite understand the American people just yet, hence you're very misleading. He did everything except for answering the question as to how did Hawaii get annexed without a treaty. But the point he's making, though, obviously he's making a reference to one, Thomas knows there's no treaty. Why does he not know? Why does he know there's no treaty? Also, when he says he doesn't understand the American people, that means Thomas is not American. Who's this guy, Thomas Clark? Folks, remember the signature petitions? The 28,000 signatures, the Hui Aloha Aina, Hawaiian Patriotic League, that was signed and it was submitted to the Senate, and it killed the treaty? Well, here's the petition for the heir of Wailuku, Maui. There's Thomas Clark right there, age 42. Next to his name, you see the word Hawaiian. That means Thomas Clark was a Hawaiian subject. Actually, Thomas Clark was actually a haole, but Hawaiian. You guys see how that term is used? One is a citizenship, the other is the ethnicity. Hawaiian is actually ethnic, not ethnic, it's actually nationality. Yeah. So he knew there was no treaty. Now, why is it that we don't know what Thomas knew? That's 1900. Today it's 2019. He obviously knew there was no treaty, so he wouldn't refer to anything being ceded, right? Something happened to us. And I covered that before, and that's called denationalization. Okay? We're led to believe something that's not true. So not only Thomas, who else knew that a joint resolution cannot annex anything? Well, Senator William Allen, in 1898, he actually put this on the record regarding the joint resolution of annexation of Hawaii. He says, the Constitution and the statutes are territorial in their operation. That is, they can have no binding force or operation beyond the territorial limits of the government in which they are promulgated. In other words, the Constitution and statutes cannot reach across the territorial boundaries of the United States into the territorial domain of another government and affect that government or persons or property therein. So he's admitting you can't pass a law annexing a foreign country. That's a senator. And there are a bunch of them that said that. Senator Pettigrew, Senator Thomas Ball from Texas, Senator Allen also concludes the joint resolution is ipso facto null and void. He just said it's nothing. So why is it that we don't know this? Obviously, Thomas knew it, and he's from Maui. This guy's a senator in the Congress. And then in 1900, the United States Congress passed another law, an act to provide a government for the territory of Hawaii. And this is where they're going to change the name of the Hawaiian government to the territory of Hawaii. And then in 1959, Public Law 86-3, the Congress passes another law transforming the territory into a state. Now, let's use Alaska as an example. Again, 1867, there was a treaty that transferred Alaska to the United States from Russia. In 1912, the United States Congress passed a law creating the territory of Alaska. And then in 1959, had a plebiscite on whether or not they should transform the territory into the state of Alaska. And it became the 49th state of the United States. So here we are at Statehood Act, 1959, which derived from a Territorial Act in 1900, which derived from no treaty, except for a joint resolution. Well, in 1993, I'm pointing out here under Public Law 103-150, they apologized for the illegal overthrow of the Hawaiian Kingdom. Question here for the council members. What was overthrown in 1893? The monarchy or the government? But it's difficult to say monarchy because Hawaii was a constitutional monarchy, and it was representative democracy. That's what it was. If you say overthrow of the monarchy, it kind of implies it was an absolute monarchy. It was actually very progressive, yeah, very constitutional, very limited. In fact, one of the provisions in the Hawaiian Kingdom Constitution says and applies to those who are going to be the monarch, serve in that office of the monarch, or serve as a representative, or even serve as a noble. It says, no one should sit upon the throne who has been convicted of an infamous crime, insane, or an idiot. Yeah, that's actually in the Hawaiian Constitution. That's limiting authority, right? But Hawaii's having experienced the insanity of King George III when Kamehameha I became a part of the British Empire. King George III lapsed into insanity, right? And he was replaced by his son, the Prince Regent, who later came to be known as King George IV. Yes.
Member Lee? Yeah, can I ask a quick question? Okay, so you said something about they cannot serve if you committed a crime. Did you say if they didn't have the proper lineage? Did you say that?
No.
Oh, I didn't hear. Okay.
No. Under Hawaiian constitutional law, the monarch has to be Aboriginal stock, the chief. Because you also had chiefs back then who weren't Aboriginal or Native. But it did limit the monarchy to the native blood, Aboriginal stock. That's actually the term they used.
Well, because the reason I'm asking is Queen Liliuokalani was adopted. She was Hanite, right?
Yeah. Well, actually, King Kalakaua, who named Liliuokalani as his successor in 1877, after the brother died, right? They're actually not Kamehameha line.
Yeah, so that.
Yeah, so you don't have to be from the Kamehameha line.
I see.
Yeah, but they were elected. So King Kalakaua was elected by the legislature in 1874 as a successor to King Lunalilo, who was elected by the legislature in 1873 because King Kamehameha V did not name a successor to the throne. But yeah, Prince Albert Kunuiakea, he's supposedly the illegitimate child of Kamehameha III, sorry. He was living at the same time in 1893. He's of the so-called Kamehameha line. He wasn't the monarch. Liliuokalani and Kalakaua were, and they're not of the Kamehameha line. So this idea of being a Kamehameha has nothing to do with Hawaiian Kingdom law. It's actually being of a nobility and then being elected to ensure you're not an idiot, you're not insane, and that you haven't been convicted of an infamous crime. That's the phrasing in the Hawaiian Constitution, right? Good point. So here we have Public Law 103-150, where they apologize for the overthrow of the government, not the Hawaiian Kingdom. But what they also have in there, it says, whereas the Republic of Hawaii also ceded 1.8 million acres of Crown, government, and public lands of the kingdom without the consent of or compensation to the native Hawaiian people of Hawaii or their sovereign government. Well, actually, nothing was ceded, and by them saying the unconsented, that means, if anything, the Hawaiian government, if it's government land, is supposed to consent to any transfer. They're admitting they didn't consent. You have a problem with the title there. They're acknowledging at least there's a cloud. But when you see that it was done without a treaty, then it's not a cloud, nothing was ceded, period. Like Thomas Clark succinctly stated, there's no treaty. So United States laws have limitations, just as Senator Allen was saying. They're limited to U.S. territory. So you have borders, and U.S. laws have no effect beyond the borders of the United States. So if that is the case, then the joint resolution of annexation has no effect of any cession. Because cession is not supposed to come from the entity that's receiving it. Cession is supposed to come from the entity that is transferring it. And the apology resolution admitted it happened without their consent, so obviously they're agreeing that a joint resolution of annexation didn't annex anything, let alone cede. Now, the United States Supreme Court, what do they say about American law? Well, it says the laws of no nation can justly extend beyond its own territories. They can have no force to control the sovereignty of any other nation. Then it goes on to state in U.S. v. Curtis Wright in 1936, neither the Constitution, the federal Constitution, nor the laws passed in pursuance of it, federal laws, have any force in foreign territory, and operations of the nation in such territory must be governed by treaties, international understandings and compacts, and the principles of international law. What we've been trying to do is explain Hawaii's situation through the American Constitution and federal laws, because we're assuming Hawaii is a part of the United States. Once we identify the fact that Hawaii is not part of the United States, we're supposed to be using international law, international understandings to understand Hawaii's situation. And that's my area in my PhD in political science. So what we have are national laws and international laws. So we got to the left, the United States of America with its territory. To the right, the Hawaiian Kingdom with its territory. United States Congress passed a law in 1898 called a Joint Resolution of Annexation. 2 years later, the Territorial Act was enacted in 1900. And then in 1959, the territory was changed to the state of Hawaii, called the Statehood Act. And then in 1993, the Congress apologizes for the illegal overthrow. And then, under the Hawaiian law, you have the 1864 Constitution. Oops. You have the 1850 Criminal Code. You have the 1859 Civil Code and the 1884 Compiled Laws. Hawaiian laws apply to Hawaiian territory. American laws apply to U.S. territory. They're separated by international law. You need a treaty in order for all those American laws to be applied in Hawaii. We don't have a treaty. That's the problem. But yet, we've been led to believe there's a treaty, and the evidence of that is we keep saying ceded lands. Ceded implies something was transferred, when in fact it wasn't. That was part of the propaganda that started in 1906 under the Program for Patriotic Exercises, which we covered in the first workshop, right? So we're led to believe something that's not true. What does apply to Hawaii's situation is international law. In particular, the 1907 Hague Convention and the 1949 Geneva Conventions. They regulate states that are occupied.
Member Shenensi, did you have a question?
Oh,
Yeah, thank you. I just had a quick question. Did the government of the Republic of Hawaii have a right to enter into any treaties or agreements with the U.S. at the time?
No, by the United States President's own admission, where he said the provisional government, when he told Congress, was neither de facto nor de jure, but self-declared. And then 1 year later, on July 3rd, these individuals changed their name to the Republic of Hawaii. They're still neither de facto nor de jure, right? And what they're trying to do is trying to get recognized from other countries around the world. Well, those recognitions of the Republic of Hawaii that took place in 1894, that is actually evidence of intervention. Evidence that other countries are intervening in the internal affairs of another country by supporting a puppet regime of the United States that the president said owes its existence to an armed invasion by the United States. Now, the one thing about the Republic, as they were trying to get recognition, they're trying to get some sense of legitimacy, which they didn't have. They did enter into a so-called treaty in 1897 with President McKinley. Queen Liliuokalani was in Washington, D.C. at that time and fought a diplomatic protest, right, in the summer of 1897, July, saying that this treaty is illegal. It's a violation of international law. And she basically says you must follow what you already committed to with James Blunt's findings and President Cleveland's conclusions. Well, President McKinley refused to take heed of the Queen's protests, and he still intended to submit the treaty to the United States Senate for approval, called ratification. And the Senate was not going to be reconvening until December of 1897. This is the summer of 1897. That is what activated in September the Hawaiian Patriotic League to gather 21,000 signatures against annexation. It also got the Hui Kalai'aina, the Hawaiian Political Association, to get 17,000 signatures against annexation. So they arrived in Washington before the Senate was going to convene in December, and they met with Senator Hoare from Massachusetts, who agreed to read in the petitions against annexation to make the record. But they chose to only use the Hui Aloha petition, not the Hui Kalai'aina, because the Hui Kalai'aina was restoration of the monarchy and against annexation. Well, their decision back then was made to only go with the Hui Aloha Aina, because all it was protesting annexation in any way, shape, or form. That's all. And the US Congress was very anti-monarchies. So that was a decision they made for the 21,000 signatures. And then they were told by Liliuokalani, who was in Washington at that time, that these officers of the two organizations, namely David Kalauokalani, a sheriff from Molokai, he was the head of the Hui Kalai'aina, and James Kaulia, an attorney, head of the Hui Aloha Aina. Their job was to pound the pavement and go to every senator who voiced an opinion that they're going to ratify the treaty, because you need 2/3 of the senators. They chiseled it down because of their activity, not just because of the petition, because of their pounding the pavement. They were the ones who killed the treaty. So by March of 1898, the treaty's dead. They can't ratify it. Spanish-American War breaks out the very next month in April, and that's when Francis Newlands introduces the joint resolution of annexation. So they were trying to do it by a treaty, but it got killed, not because of their good graces, but because of the activism by Hawaiians who killed it. That story is covered by Noinoi Silva in her book, right? That was the topic of her doctoral dissertation. She's now a professor in political science up at UH. So again, we don't know this history, but it's now starting to unveil itself with profound ramifications. So what we have here is really a governmental infrastructure that started in the Kingdom era. Separation of powers, right? Legislative, executive, judicial. All we had from 1893 was the same governmental structure, but name change. From Hawaiian Kingdom to provisional government to Republic of Hawaii, Republic of Hawaii, Republic of Hawaii to the Territory of Hawaii, and from Territory of Hawaii to the State of Hawaii. In fact, everything here goes back to 1845. Yeah, this is not a creation of the United States. This was called a hijacking. Change the head, keep the car. If anything, they painted the car red, white, and blue. But it's a different car. And now after 100 years, the paint is chipping. And now people are starting to ask the right questions. Wait a minute, I see a different color of this car. Now, in 1988, 90 years after the so-called annexation of Hawaii by a joint resolution, the Office of Legal Counsel from the Department of Justice came out with an opinion. That opinion hasn't changed. Now, this is the same Office of Legal Counsel that Robert Mueller was relying on, that a sitting president cannot be indicted. This is the same office, different subject though. What they're looking at and what they stumbled over was Hawaii's situation. So Douglas Kamayak, Assistant Attorney General, stated in his opinion, despite these constitutional objections, Congress approved the joint resolution and President McKinley signed the measure in 1898. Nevertheless, whether this action demonstrates the constitutional power of Congress to acquire territory is certainly questionable because Congress has no effect beyond its borders. Then he concludes, it is therefore unclear which constitutional power Congress exercised when it acquired Hawaii by a joint resolution, because you can't. But they even stumbled on this information, and that's in Washington, D.C. What I find ironic is 5 years later, the apology resolution came out, and now it's going to steer this issue into making it native and an issue of self-determination, right? And Native Hawaiians are indigenous people, similar to Native Americans. That's called the bait and shift, right? Or what I would call the red herring, or Hawaiians from Lahaina is called throwing the akule over here, as opposed to throwing the red herring over there. Look over here. No, stay focused. 1988, they said, we don't know how Hawaii was annexed. Now, this information is very complex. This is not something that people can just get, right? Well, Matthew Craven, Dr. Matthew Craven, who later became the Dean of the University of London Law School in Great Britain, authored this opinion, and you folks have a copy of that. This is in 2002, being a portion of a legal brief provided for the Acting Council of Regency. If we weren't the Council of Regency, we wouldn't get this legal opinion from this expert. And he covers why the Hawaiian Kingdom still exists, covers it in detail. Any claim that the United States may make over Hawaii, he covers it. He states the implications of continuity of the Hawaiian Kingdom in case of Hawaii are several. A, that authority exercised by the United States over Hawaii is not one of sovereignty, i.e., that the U.S. has no legally protected right to exercise that control and that it has no original claim to the territory of Hawaii or right to obedience on the part of the Hawaiian population. Furthermore, the extension of U.S. laws to Hawaii, apart from those that may be justified by reference to the law of belligerent occupation, would be contrary to the terms of international law. It's all laid out here in this legal opinion. Now, remember the last meeting? This is after we got back from the Netherlands, from the Permanent Court of Arbitration. We needed people to be educated. Why not access an international law expert from the University of London? And he was actually recommended to me by James Crawford, who now currently sits as a judge on the International Court of Justice. James Crawford was one of the arbitrators in Larson versus the Hawaiian Kingdom arbitration case. Now, what we also have is this just came out last month. And this is a legal opinion on war crimes related to the United States occupation of the Hawaiian Kingdom since January 17, 1893. And it was done by William Chabas. He's a professor of international law, and you folks also have this copy. He is the leading expert on international criminal law and war crimes. So he writes, this legal opinion is made at the request of the head of the Hawaiian Royal Commission of Inquiry, Dr. David Keanu Sai, in his letter of May 28th, requesting of me a legal opinion addressing the applicable international law, main facts and the related assessment, allegations of war crimes, and defining the material elements of the war crimes in order to identify mens rea, the guilty mind, and actus reus, conduct or action tied directly to a crime. It is premised on the assumption that the Hawaiian Kingdom was occupied by the United States in 1893 and that it remained so since that time. Reference has been made to the expert report produced by Professor Matthew Craven, which is the opinion you folks have, dealing with the legal status of Hawaii and the view that it has been and remains in a situation of belligerent occupation, resulting in the application of the relevant rules of international law, particularly those set out in the Hague Convention of 1899 and 1907 and the Fort Geneva Convention of 1949. So you're getting experts looking into these areas. This is not people giving unqualified opinion. These are legal opinions coming from recognized experts internationally. He also states that statutory limitation of war crimes is prohibited by customary law. What he's referring to is when you commit a war crime, there's no statute of limitation. There is none. And that's what people have to be careful about. In fact, they're still hunting Nazis in South America. The prohibition of statutory limitation for war crimes has been proclaimed in several resolutions of the United Nations General Assembly. In a diplomatic note to the government of Iraq in 1991 regarding Iraq's occupation of Kuwait, the government of the United States declared that under international law, violations of the Geneva Conventions, the Geneva Protocol of 1925, or related international laws of armed conflict are war crimes, and individuals guilty of such violations may be subject to prosecution at any time without any statute of limitation. This includes members of the Iraqi armed forces and civilian government officials. That's the direct quote from the United States diplomat to Iraq. So it's a pretty heavy statement to make. No statute of limitations, don't commit the war crimes. So what is the international law of occupation? Well, the first rule is to maintain the status quo of the occupied state, its territory, laws, and citizenry. You're not supposed to change it because occupations are not supposed to last over 100 years. And the only why it lasted over 100 years is because we were brainwashed into believing we're American. We're brainwashed into believing this is America. That's how it lasted. Because we didn't know, because we were denationalized. That doesn't change anything. It's just that we're all evidence of the war crime of denationalization. The second rule is for the occupying country to administer the laws of the occupied country through a military government similar to the occupation of Japan from 1945 to 1952. A military government takes over an already existing government in the occupied country by establishing a military governor. Third rule is that occupations are regulated by international law and not the laws of the occupying country, because they're limited to U.S. territory in this case. So, what are Hawaiian laws? What existed back then in 1893? Well, this is the compiled laws of the Hawaiian Kingdom, which is the Civil Code. Section 6 of the Hawaiian Civil Code says the laws are obligatory upon all persons, whether subjects of this kingdom or citizens or subjects of any foreign state, while within the limits of this kingdom. The property of all such persons, while such property is within the territorial jurisdiction of this kingdom, is also subject to the laws. That's for everyone in Hawaii. So in this context, I would like to share with you about land titles in the kingdom, right? So the idea of crown lands, okay, what are they? Well, crown lands were identified as crown lands in 1848. After listing all the lands, which is about 1 million acres, all the different ahupua'a, in this statute, it says, these lands are to be the private lands of His Majesty Kamehameha III, to have and to hold to himself his heirs and successors forever. And said lands shall be regulated and disposed of according to his royal will and pleasure, subject only to the rights of tenants. Because in Hawaiian law, native tenants still have rights in that land to get a fee simple title. Now in 1965, the Hawaiian Kingdom legislature passed an act establishing the Crown Land Estate, or the Crown Land Commissioners, and made all crown lands inalienable. In particular, I'm going to read this part at the bottom. And whereas by the proper construction of the statute, the words heirs and successors, they're referring to the 1848 statute, it means the heirs and successors to the royal office. It doesn't mean his family. That's why Queen Liliuokalani was a successor in that office, even though Liliuokalani was not a Kamehameha. And this is what created the Crown Land Commissioners, who are in control of the Crown lands, and you can only get, from 1865, a 30-year lease. You can't get a fee simple ownership on Crown land, according to the statute. Now, government lands were about 1.5 million acres identified at that time on all the islands by the statute of 1848. And it says that these lands are made over to the chiefs and people, which is the House of Nobles and Representatives, by our sovereign Lord the King, and we do hereby declare these lands to be set apart as the lands of the Hawaiian government, subject always to the rights of tenants. Again, native tenant rights are in all government lands. Okay? And we do hereby appoint the Minister of the Interior and his successors in office to direct, superintend, and dispose of said lands. So remember the ceded lands, so-called ceded lands? Well, first of all, you would need consent for government lands from the Minister of the Interior. They didn't get it. If you're going to get consent for the Crown lands, you got to get it from the Crown Land Commissioners. They didn't get it. The United States just said, we have it. That's not ceded lands. You just took control of other lands that other people or entities have control over, title to. But that didn't create a title for the United States, who would then transfer it supposedly to the state of Hawaii in 1959. And then Hawaiian Homes currently has Crown lands. And the Department of, what department is that? Land and Natural Resources is in control of government land. Right? Now, all land titles in Hawaii originate from Land Commission Awards and Royal Patents. And on this Royal Patent, even though the title was given to this individual, it still has reserving the rights of native tenants. So you can't take that condition out. That secures and locks in native tenant rights so that they could possibly get a fee simple title or have access to gathering. Okay? But it's still there. That is something unique only under Hawaiian Kingdom law. You don't have that in any other country. If anything, in other countries, it's the aristocrats that own the land. And the others were considered peasants that worked on the land.
Was anything
Member Lee.
lost in translation with regard to the Hawaiian language, English language?
No, no,
So there's no disputes there?
no, no. So in the Hawaiian language, when they refer to fee simple title, it's called makeano alodio. Alodio is a Hawaiianization of the word alodio, which the Hawaiian Kingdom identified as fee simple. The words makeano alodio malalo iho oke no malalo iho oke ano alodio is less than alodio, or in other words, a life estate. And ho'oli malima is a leasehold property. So in the Hawaiian law was in both Hawaiian and English. Yeah. Now, conveyances under Hawaiian law, once you acquire property, Section 1262, all deeds, leases for a term of more than 1 year, or other conveyances of real estate within this kingdom shall be recorded in the office of the Registrar of Conveyances. You know that Bureau of Conveyances that we have today? That's from 1845. Remember, they just changed the control of an already existing system. And every such conveyance not so recorded shall be void. So you have to make sure that the registrar is a valid officer of the court. Of the country, the Hawaiian Kingdom. Also, Section 1267, no person who is not a subject of this kingdom shall be eligible to the office of notary public. So before you can file a deed or a lease or a mortgage in the Bureau of Conveyances, you have to get it notarized by a Hawaiian Kingdom notary. You can't get it notarized by an American notary. You can't get it notarized by an Iraqi notary. You have to get it notarized, if you're in Hawaii, a Hawaiian Kingdom notary. Can you see we're going to run into a problem with the United States not administering Hawaiian Kingdom law? This is called a domino effect. This is not just a native issue. This is the whole system is now going to be operating on a false premise. And the only way you can maintain that is through denationalization and keep everybody saying ceded lands, or this is America, or this is not occupation. So deeds of conveyances of real property and mortgages after January 17 cannot be considered lawfully executed because the registrar of conveyances and notaries were insurgents. Yeah, President Cleveland referred to the provisional government not only as neither de facto nor de jure as a government, but self-declared. He specifically referred to them as insurgents. President Cleveland, in his message to the Congress on December 18th, stated, when our minister recognized the provisional government, the only basis upon which it rested was the fact that the Committee of Safety declared it to exist. It was neither a government de facto nor de jure. So who's the notaries that are notarizing deeds after January 17th? And the whole point about a notary is supposed to ensure that the person conveying the property is of sound mind and body. Did you know that if the notary smells liquor on you, they can't notarize the document? They'll say, come back tomorrow. That's what a notary is for, to acknowledge, right? Knowing that President Cleveland identified them as insurgents, how do I know that this guy didn't have a gun to his head with the notary? I don't. But I do know the notary was an insurgent, not a notary. Yes, Mike.
Yeah, sorry for the interruption, Doctor. Just a quick clarification. Who made up the Committee of Safety? Was it mostly outside residents just recently had moved to Hawaii at the time, or were they made up of a majority of existing residents?
That's a good point. So the Committee of Safety was made up of 13 people, okay? And actually, 6 of them were Hawaiian subjects, including Samuel Damon. Samuel Damon's Haole, but he's Hawaiian, right? A Hawaiian subject. You had 6 Hawaiians, 5 Americans, 1 British subject, and 1 German. That was the Committee of Safety.
On what basis were they? They just formed amongst themselves, or were they put in by?
They actually took that name, Committee of Safety, from the French Revolution and gave the impression they're taking over a queen who's a tyrant. It was all part of the propaganda. That's why they called themselves the Committee of Safety. It's all propaganda. That's what this whole thing was all about back then. Now, propaganda cannot get you too far unless you're protected by the U.S. Marines. And then, to ensure their protection, start brainwashing all the children in the schools starting in 1906, which is why we've come to this point where we don't know who were in the Committee of Safety when that should be a part of our classes that we learn. These are insurgents. But we do teach that now at the university. Yeah, people are now coming out being aware of what happened. But good question. Yeah. Now, the Hawaiian Kingdom law was to be administered by the president through military government in accordance with the Hague and Geneva Conventions. Now, somebody might say, oh, but that's 1907 Hague Convention. What happened in Hawaii was 1893. Actually, in 1907, it's a codification of customary law of war that existed in 1893. To codify something is not to create the law. They're just putting it in treaty form. So when the law says you're supposed to administer the laws of the occupied state, that's a customary law. After 1899 and 1907, all you have to say is Article 43, Article 64 of the Geneva Convention. That's the codification of existing laws of war. Now, the United States failed to administer Hawaiian Kingdom laws, which is an obligation under international law. That's why we're in the problem we're in today. It's their fault, it's not our fault. It's the McKinley administration, a former administration. It's not the administration of today, no matter how much we may dislike or like it. They did it back then. They didn't follow the law, and we're the consequence of it. Consequently, this failure renders all conveyances of real estate and mortgages securing the repayment of loans within Hawaiian territory since January 17, 1893, to the present, null and void. Whoa, now everything is affected by the fact that who's the notary? Where's the notary? Very simple. All titles today, if you look at a tax map key, you see number 21, you got 19 over there, I believe, 40. They all come from land commission awards or royal patents. That's the origin of titles in Hawaii. So what you're supposed to do is your title is merely derivative of what was there in the past. That's how it works. So here we have a chain of title. Commandment III began to formalize land titles in Hawaii in 1845 with the formation of the Bureau of Conveyances, as well as the Board of Commissioners to quiet land titles. Let's say this person here received a road patent, number 1225, Daniel Collier. In order for him to transfer that property to whoever he wanted, whether a portion of that road patent, maybe 5 acres, or maybe the whole 5 acres itself, you got to get it notarized, and then you record it in the Bureau. So let's say 1874, a warranty deed is recorded in the Bureau of Conveyances. Then that person conveyed it in 1884. Then in 1894, there was a conveyance number 3, which was later conveyed in 1897, 1975, and somebody today owns the property. What you have there is a chain of title, okay? And that person claiming the property today can only claim what the person conveyed to him. And that person who conveyed it to him can only claim what that previous person conveyed to him. So you would have to do a title search to determine whether or not that owner today is valid. Let's say he might be claiming to own Kaho'olawe. Well, you got to have a chain of title that shows you have a vested interest in Kaho'olawe. So what we have is a break in the chain of title. No treaty in 1898. All we have is a joint resolution. Well, that notary in 1975 was a state of Hawaii notary. Well, that just took that entity out. And then what we have, January 17, 1893, U.S. fails to administer Hawaiian Kingdom law. So the conveyance in 1894 and 1897 are taken out. So what you have there is a problem. The person today cannot claim to have a clear title. Now, when does all this come into play? During escrow. Many of you may have had mortgages. I'm going to cover that. And you're going to see the title companies are hooked on this. And they made some bad decisions. So what I need to do is explain some terminology, which is very important to understand how the escrow process works. A promissory note. A promissory note is a written document where you promise to pay back the money. That's called a loan, right? A mortgage. A mortgage is a lien, which is a right to hold on to a property to ensure the repayment of the loan. People constantly misuse the term mortgage by saying, I pay a mortgage. No, you don't pay a mortgage. You pay a loan secured by a mortgage. A mortgage is a lien. It's a security instrument. In fact, a mortgage is what you convey to the bank to hold on to ensure the repayment. After you pay off the loan, the bank releases the mortgage back to you. So to say that you pay a mortgage would be incorrect. Whether or not you have a mortgage, you still got to pay the money back. And you have a deed, which is a legal instrument that is used to assign ownership of real property. So here's an example of a promissory note, okay? Borrowers promise to pay $290,000, okay? That's a loan, that's a contract. This is a mortgage. And you notice it's a security instrument. That's all it is. It's what you give to the bank to hold on to and authorize them to foreclose on you if you default on the loan. The foreclosures take place because of the mortgage. You authorize the bank to do that. Okay? So there's nothing wrong with the mortgage. Because if you're going to sign a note to me, borrowing $290,000 from me, how do I guarantee you're going to pay that money back? I need something to hold on to. It's called a lien. And this is a deed. And if you notice, it's recorded in the Bureau of Conveyances, and it's notarized. Okay. Another term that needs to be understood is title insurance. So title insurance is a policy issued by a title company after searching the title, representing the state of that title, and ensuring the accuracy of its search against claims of title defects. Okay, so when you go to escrow, before the bank accepts your mortgage, they have to verify you own the land. So they do a title search. Based upon that title search that's supposed to go back to 1845, you have a title insurance company agent there. And that agent will underwrite the title report. And it would be in the amount of money you're borrowing from the bank. The reason is the bank has to make sure they're protected, because if they take the mortgage, accept the mortgage by title guarantees, use them as an example, title guarantees, title report that says the title is valid, that's a risk for them. Because what if it's not valid? Somebody didn't do a good title search. What you have there is an invalid lien. The bank cannot foreclose. They got to find another way to collect. And what they do is, in order to collect when the mortgage is invalid, title insurance. That's what pays off the loan. Title insurance is an indemnity contract that does not guarantee the state of land titles, but covers loss incurred from a defect in land titles. You got to be an expert title abstractor to do a title search, enough for an insurance company to underwrite it. And a defect is the want or absence of some legal requisite, like a notary. So the lender's title insurance policy. Did you know that when you go to a bank, go to the bank, you want to borrow the money, the bank says go to Escrow, which is a third party, open up an account, they put the money in there that you're going to borrow, but it won't close until you achieve certain things. One of them, you get title insurance, called a lender's policy. A policy that protects the lender from losses incurred as a result of the defect in title. Then you also are going to get what is called an owner's policy, if you so choose. So a lender's policy is in the amount of the money you borrowed. An owner's policy is the appraised value of the property. So if you find out that your title is defective, you have an owner's policy that can pay out you the appraised value of that property. And each of these policies is a one-time premium, not monthly, a one-time premium. Now, when you go to escrow, you have what is called the lender's instructions. Okay? So it says here, number 1, title policy requirements. The title policy must ensure the mortgage as a good and valid lien. That's why you do a title report. Just to make sure I'm not trying to mortgage Ko'olawe today to Bank of America to borrow $290,000. And this is what a lender's title insurance policy looks like, which is in the amount of the money borrowed. And this is an owner's policy that protects the owner of the property. So if something is wrong with the title, you can file a claim, and it pays you if it's an owner's policy, and it pays off your loan if it's a lender's policy. So this is your HUD-1 statement, your closing costs. It's all in there. Go to section 1100. Title charges. You see where it says lender's coverage and owner's coverage? That's the amount of money that has a coverage of the policy. Money owed to the bank in case there's a defect in the title, money owed to you in case there's a defect in title. So in the lender's title insurance policy, covered risks. A defect in title caused by forgery, fraud, undue influence, duress, incompetency, incapacity, impersonation. Also notarized to the right. A document not affecting title properly created. A document not properly filed, like in the Bureau of Conveyances. Obviously, it hits all the covered risks regarding Hawaii's occupation. The registrar is not valid, and the notaries are not valid. Now, for a complete loss of title because a deed was not properly notarized, it puts everyone today in a position. What about my title, right? Is somebody going to come and take it? No, they won't. You actually have what is called an equitable interest. So in this court case, the Ohio Supreme Court stated, the legal title to a parcel of real property did not pass where the grantor signed the deed outside the presence of both witnesses and did not appear before the notary public who certified the acknowledgement. Thus, the purchasers at most had an equitable interest in the property, still titled in the grantors that was not created upon the payment of consideration. So everyone who owns property today or thinks they own property today, you provided valuable consideration for that, right? You paid somebody for it. What you have is an equitable interest. All you got to do is fix the notary. Then it's okay. But up to this point, nobody's following Hawaiian Kingdom law. But yet Hawaiian land titles, all land titles today come from the Hawaiian Kingdom. Everyone admits that. Now the owner's policy, it also has a provision in there like it has in the lender's policy. Proof of loss or damage. The proof of loss or damage shall describe the defect in or lien or encumbrance on the title or other matter insured against by this policy, like defective notary. So you would have to, let's say, get a copy of my PowerPoint and send a claim in to your insurance company and say, here's the evidence of the defect. And they're supposed to investigate it. And the insurance company, the title insurance company, will have to try to show that Hawaii was annexed by a treaty. They would have to try to show that President Cleveland didn't say these individuals were insurgents, which we know they can. Can you see what chaos this would create? This is huge. So, put it all together here. You get the borrower and the lender and the title insurance. The borrower signs a promissory note, okay, a contract for money borrowed. The borrower gives a mortgage to the bank to hold on to and purchase title insurance to protect the bank in case the mortgage is invalid, in case the title report was not accurate. Once they find out today that all titles stopped in 1893, well, there went the mortgage. The bank cannot collect. What happens is the title insurance pays off the loan. That's how it works. Very simple, with profound ramifications. A lot of pressure on the title insurance. Let me show you how profound it gets. Remember the laws of the Hawaiian Kingdom got to be followed? According to the 1880 co-partnership statute, if you want to have a co-partnership under Hawaiian Kingdom law, you got to register your articles of agreement with the Bureau of Conveyances. They weren't only registering titles, they were actually registering co-partnership agreements. Whenever any two or more persons shall carry on business in this kingdom in co-partnership, it shall be incumbent for such persons to file in the office of the Minister of the Interior, the Bureau of Conveyances, their articles of agreement. In 1995, Perfect Title Company was established under Hawaiian Kingdom law in accordance with the co-partnership firm. So this deed of general partnership was filed in the Bureau of Conveyances. Now, how do you get around the notary problem and the registrar problem? Actually, where it says notary, that the partners are doing this under duress, that this is not the appropriate notary. So they're making a record of it, but they need to get it recorded. So they're acknowledging we're going through an illegal management, but we need to get it into the Bureau. So the partnership was formed. The above mentioned parties have agreed to form a general partnership under the firm name of Perfect Title Company in the business of researching, manufacturing, and selling of land title reports. It's going to be like a title guarantee, right? We're going to do title reports, and we're going to prove nobody owns land, because we're going to give you the evidence so you file your insurance claims with the insurance company for them to refute. That's how it's supposed to work. And if they can prove our title reports are wrong, then we're all good. And then in 1996, everything hit the fan. Front page. People still make reference to this today like we're bilking people back then. No. Was doing title reports. Title firm disdains land claims made since end of monarchy. Now, watch when you read what is up there then with what you now know. You're going to go, yeah, that makes sense. Imagine reading what they said back then. Back then, it sounds ludicrous. Perfect Title considers any certificate transferred after the 1893 overthrow of Queen Lili'uokalani to be invalid because it passed through individuals or institutions treasonous to the crown. That makes perfect sense now, right? 1996, that's crazy talk. What do you mean? And then the firestorm. Now this happened. There was a seminar put on by the Hawaii Developers Council in July of 1997. And it was at the Hawaii Prince Hotel. 500 people showed up. And the title of it was Perfect Title, Scam or Restoration. That was the title that the Hawaii Developers Council put to it, not us. On this panel is going to be David Peach, president of Title Guarantee Escrow, Bruce Graham from Ashford and Riston. He also teaches land titles at the University of Hawaii Law School. Neil Hulbert from Alston and Hunt Law Firm, representing Chicago Title Insurance Company. Myself, Donald Lewis, my partner, and an attorney from Bank of Hawaii to moderate. It was like taking candy away from kids. They thought we were sovereignty activists. We had a slideshow, back then no PowerPoint, slideshow, showing the original documents, names crossed out, title insurance, native tenant rights. People walked out of that seminar dumbfounded. I was approached by Bruce Graham. Oh, question? Sorry.
Dr. Sai, didn't you own that company?
Yeah, I was a partner of it.
You own half of that company?
Yep, with Donald Lewis. And Donald Lewis was a former principal, retired, of Locations, Inc., which now is Prudential Location. So he had a definite real estate background as well. I came in contributing to the partnership my expertise in land titles. So I trained title abstractors to do title reports. But yeah, I was a 50% partner. Now, after the presentation, Bruce Graham comes up to me, okay? And he says, you know, Keanu, we need to talk. I said, okay, what's wrong? He says, you're taking these people down the wrong road. People are going to get hurt. I said, Bruce, I'm not here to argue with you. This is a title report. And I sent you an example of a title report from our company. And I said, all you have to do is to go line by line and refute it. And if you can refute it, get us on fraud. It's just a title report. He said, I looked at it. It is historically and factually correct. So I said, so what's the problem? He says, well, America's here, and that's just the way it is. I said, I didn't know America was involved with title insurance, because that's what it is. So we left. I knew our title reports were solid. Nobody can refute it, but you don't hear Bruce Graham saying it in public, right? 1 week later, we get arrested. Our offices get raided by the Honolulu Police Department, white collar crime unit, which I'm going to show you. Leading up to that is a drive from Title Guarantee and John Jabinski, legal counsel for Title Guarantee. They're starting the sound bites. They're saying that Perfect Title and Keanu Sai are telling elderly people not to pay their mortgages. That was the sound bites. Yeah. In fact, Joe Moore from Channel 2 News says that I'm a charlatan. Did you know I had to look that up? Because I didn't know what a charlatan was. That's a shyster. Wow. Where's the evidence of this stuff? Barbara Marshall came into the office. She asked me, you remember she was at Action Line, if you folks remember back then, Channel 2 News. She says, are you telling people don't pay their mortgages? I said, you don't say that because that's a lien. Now, are you telling people, we're telling people don't pay their loan? Of course not. They got title insurance. That's what covers their debt. She didn't put that on the news. Joe Moore called me a charlatan. So there's the drumbeat. Title disputes bring trouble to IO homes. Courts should punish land title scam artists. State must do more to stabilize titles. Perfect Title focus of criminal probe, right? Says Perfect Title has created chaos in Hawaii's real estate industry with its claim that current land titles are no good. The company reaches those conclusions using 19th century Hawaiian Kingdom law, which it says is still in effect, and by searching property records dating to the 1840s. Again, today, that makes perfect sense, right? 1997, that's lunacy. Crazy people, ripping people off. Officers get raided, as I told you, from the Honolulu Police Department White Collar Crime Unit. As part of a state criminal investigation, Honolulu Police yesterday arrested Donald Lewis, David Keanu Sai, and a company secretary for investigation of theft, racketeering, and tax evasion. Ooh, you see how hard it's coming down? Because it's a threat. All driven by the title companies. That's what's going on. So what happens is the White Collar Crime Unit, CID, is the one who raided the office. We're on the corner of Merchant and Richard Street. They blocked the street off. They're making a big spectacle. I'm coming down in handcuffs, right? Waiting outside in the van, the police van, is Detective Jill Cowie. She's from the White Collar Crime Unit. She's crying. She comes out, she hugs me. She says, Keanu, we weren't investigating you. This came from the top. That's why she refused to participate. I said, it's okay, Jill. It's fine. Now, why is Jill saying that? Because 2 months earlier, I was asked, because I'm a commitment grad, my classmates and friends are police officers. One of the sergeants from the SSD, the SWAT team, they're watching what's going on in the news. He calls me and says, hey, Keanu, what the hell is going on? I said, bro, this is all made up stuff. He goes, they're saying you're committing crimes. You're ripping people off. Do you mind if you come and give a presentation to the SSD on the Beretania Street, the substation? So I went into the basement, saw my friend, I'm not gonna say his name, right? So who's there? Detective Joe Cowie from the White Collar Crime Unit. I do a presentation. They all said, this is land titles. It's not criminal activity. I said, exactly. It's just land titles. That's why she refused to participate. But remember, this is what happens when you share the truth. Then they get us on attempted theft after they smear us, right? What they're trying to do is get everybody to not listen to us. That was the whole point. And who's at risk over here? The title companies, the title insurance. And I did hear that there was a meeting with Mazie Hirono, with landowners who said, if you don't take perfect title down, you're going down with us, called the state of Hawaii, because everybody's all tied to land titles all over. And that's what prompted the call for the White Collar Crime Unit to raid us. Yeah, Hawaii's too small, right? So they can't get us on racketeering, yeah? They get us on a so-called attempted theft of property. We attempted to steal land by doing a title report. How come you're not arresting title guarantee? It's ludicrous. You can only, well, you'll see. Perfect Title Company executives Donald Lewis and David Keanu Sai and 2 other people indicted on theft charges this week can expect to be arrested within days if they don't turn themselves in, the Attorney General's office said today. Now, according to criminal law, okay, Cook and Marcus, the subject of theft at common law is personal property. Interest in real property is not included. What that means is personal property, which is movable, is the subject of theft or attempted theft. Real property, which is immovable, you can't steal it. You might trespass on it, right? But you can't steal it. A theft prosecution can be possible with the criminal actor having power as a trustee, attorney, or otherwise to dispose of other's real estate, does so in his own benefit in violation of his trust. I'm not a trustee for that property. It was a subject of a title report. I have no connection to that property. What I did find out was the person who claimed the property that the previous owner did a title report on, he was an attorney for the Department of Commerce and Consumer Affairs. Yeah, that's where the complaint came from. And then I'm over there in the trial. I'm going to get railroaded. Nobody's listening. I better get ready to go to prison. I better call my friends who, we're not just police officers, we're also ACOs. You know, hey, I think I might be coming in. Facing 10 years in prison, Class B felony. This is all trumped up. Comes out, 3 found guilty of attempted theft. I'm sitting there, I'm getting railroaded. I'm getting railroaded. And did you know, when that started to happen, that's when I took my ring off. Nobody knows who's my family. Nobody's gonna know my wife and my 2 kids. Now that I'm a doctor, and I'm saying the same thing, I put the ring back on. But actually, it never fit. So last year I had to go get it resized. So here we go, 3 found guilty of attempted theft. Star Advertiser says the verdict culminates the state's investigation into the now defunct company, which stirred widespread anxiety in the real estate industry when it challenged property titles based on the laws of the Hawaiian Kingdom before the 1893 overthrow of Queen Liliuokalani. Again, makes perfect sense now. It was crazy talk back then. Now, this whole thing was manufactured. So remember that war crimes? The legal opinion? There's no statute of limitation for war crimes. Is there a particular war crime that was committed against me? It's called the elements of war crime of deprivation of a fair and regular trial. That's a war crime. And there's no statute of limitation for that. And you know what's good about the courts? It preserves the records. Oh, it's all there. Remember the Royal Commission of Inquiry that I shared with you folks? That's one of the investigations. A lot of them are coming out of the courts. So people got to be really careful in addressing these issues and don't jump the gun. So, in light of the craziness and the attacks that have happened when you expose, today is a different time. Very different from the 1990s. But yet people today still try to bring that up. They were telling elderly people don't pay their mortgage. It was all lies. Complete lies. I should be in prison right now if all these things are true with what they're saying I did, right? So today's different. People are educated. People are asking the right questions, right? One particular question that was asked by the chair, asking me what are my thoughts on Mauna Kea, TMT. And I said, the issue with Mauna Kea is the lease. The lease, not the governor, not anybody else, the lease. So here's the lease, 1968, from the State of Hawaii Board of Land and Natural Resources to the University of Hawaii. That is for Mauna Kea, the summit, right? And then the Board of Regents subleased properties to the other telescopes that were built, and then also subleased it to TMT, which has contracted Goodfellow to do the construction. All of that stems from an invalid lease. So, take a look at that word right there, ka'ohe. That is the ahupua'a of ka'ohe on the Big Island. First question is, who owns ka'ohe? That's government land. There it is, from 1848. Controlled by the Minister of the Interior. Did the Minister of the Interior in 1893 transfer anything to anybody? No. In fact, in 1993, the apology resolution acknowledged it was done without consent from the sovereign government. That means that lease is invalid. The lease not just to UH, but also the subleases to the previous telescopes and also to TMT right now. And you got Goodfellow operating on the assumption that the sublease is valid and it is a contract to do jobs, which is good, but it's based upon an invalid lease. Can you see who's really trespassing on Mauna Kea? It's not the people who are trying to stop it from happening. It's actually the ones that are trying to make it happen. So the Hawaiian government did not consent to any conveyance of the ahupua of Ka'ohe. Now I'm talking 1893. Whether we have a government today is irrelevant. We're talking 1893. We're not talking about a sovereignty group. The University of Hawaii cannot claim to have a valid lease from the state of Hawaii in 1968. TMT cannot claim to have valid sublease from the University of Hawaii. Goodfellow Company cannot claim to have a valid contract to build TMT. And building TMT without the consent of the Hawaiian government is the war crime of destruction of property and pillaging. Remember the legal opinion from the guy from London, the renowned expert? Elements of the war crime of confiscation or destruction of property. First element, the perpetrator confiscated or destroyed property in an occupied territory, be it that belonging to the state or to individuals. Ka'ohe belongs to the Hawaiian state under the Minister of the Interior. The confiscation or destruction was not justified by military purposes of the occupation or by the public interest. That's true. Did you know that the 13 telescopes that were built already, that's called destruction of property. That comes under those war crimes, that war crime. Now, Haleakala, the telescope up there, I believe it's on the ahupua of Pulehunui. Pulehunui is government land, just like Ka'ohe. But the area up there was actually by executive order of Quinn back in 1961, established it for the University of Hawaii. But I believe it sits within the Ahupu of Kaohe. That means that's a war crime, destruction of property, because it happened without the consent of the proper owners. Can you see the impact that this is having? Nothing is hidden. Now the question is, how do you fix the problem, right? But have I done a good job explaining the problem? Yeah. Now what? And how do we fix it? Because you folks here have a particular role in fixing the problem. And that was the last presentation, remember? The last workshop. That the county council actually has the ability to do things now that it is recognized as an occupying power under the laws of occupation. Whereas prior to that, no. So remember the proclamation, the provisional laws. That's one way to fix the notaries. The notary problem. First step, notaries and registrar from 1893 to the present. This proclamation, which we covered in the first or the second workshop, says, and we do hereby proclaim that from the date of this proclamation, 2014, all laws that have emanated from an unlawful legislature since the insurrection began in 1887 to the present, to include United States legislation, shall be the provisional laws of the realm, okay, with the express proviso that these provisional laws do not run contrary to the express reason, spirit of the laws of the Hawaiian Kingdom prior to 1887, the international laws of occupation and international humanitarian law, and if it be the case, they shall be regarded as invalid and void. So that was done in 2014. So that provides a transition. The problem is the Council of Regency is not in effective control. So the last workshop that we did, the second one, remember I gave you guys that copy from E.L. Benveniste? He authored the Law of Occupation. I provided you chapter 4, the relationship between the occupier and the occupied governments. That's what he's referring to. Because the occupied government has no effective control, they can issue proclamations, but it's up to the occupying power to implement it. Until then, it's just a proclamation. There's no effectiveness, no enforcement. So even though the proclamation was made in 2014, the notaries are still invalid until the state of Hawaii and the counties do something to make them valid. So how do you implement? Well, county councils, to include Maui County Council, enact legislation implementing the proclamation of provisional laws for each of their county ordinances. But the notaries are not from the counties, right? The notaries are from the state. The state of Hawaii also needs to enact legislation implementing the proclamation of provisional laws for the state of Hawaii statutes. So you got ordinances and you got statutes. State of Hawaii works with the Regency to resolve all land titles that derive from the government and from the Crown lands, because we are the ones that represent, provisionally, the government and the Crown Land Commissioners. So we could consent, if we have that authority, in order to fix that problem. So let's say people in Leali'i, the Leali'i project in Lahaina, that's actually Crown land in Hawaiian homes. It's supposed to be 30-year leases, but remember they're native Hawaiians. Remember native tenant rights? They get a fee simple title. So those estates over there would actually be fee simple, not 99-year lease, because that's an American law. But if you're a non-native and you're living on Crown lands today, let's say in Waimanalo, that fee simple cannot be given, but it can be transformed into a 30-year lease. It's to fix the title. So what we have here is looking into what the laws are and what are consistent and what are inconsistent. That's what's important. So the county council, all of them, which includes you folks, you don't have to wait till the others, you can start that process to look into what laws are consistent and what laws are not inconsistent, and get Corporation Counsel to look at it. That's how it works. Utilize people in positions to do their job. That's how everything works. It's not like I'm trying to tell you how to do things, but how to work within the system that we have already in light of our dire situation and realizing this whole thing is all blown up.
Member Lee.
Yeah, Dr.
I'm sorry.
Sai,